Now in Texas, the sweeping changes that came in 2003 affected not only how you prosecute the claim, but it also affected what you could recover and how you could hold the healthcare provider responsible. Tell us more about that.
One thing that folks need to understand is that part of the large package that limited patients' rights in 2003 and has now been the law of the state of Texas for over 10 years has been that there's a cap on what they can recover. And unfortunately, the law in Texas now is if an anesthesiologist leaves a patient blind after a surgical procedure, that blindness is worth no more than $250,000. If a surgeon leaves a patient a quadriplegic because they sever the spinal cord during surgery or injure the spinal cord, that quadriplegia is worth nothing more than $250,000. If a heart surgeon punctures the heart during a cardiac catheterization procedure and somebody bleeds out and is left a cardiac cripple, that injury and the impairments that are caused by it is worth nothing more than $250,000. Now, the medical expenses that can be recovered for the future needs to treat that injury aren't capped. But every patient in Texas begins essentially behind the curve because their damages for all of their physical impairment, for all of their pain and suffering, for all of the anguish that they've gone through for the injury they've suffered is capped by this overarching umbrella of $250,000 for all the physicians and then also for the hospital if there was hospital negligence. And that's one of the challenges in medical malpractice that everybody needs to understand. But we've been fortunate as a law firm to continue to prosecute those cases even under that kind of burden law by looking at maximizing the value in every way we can for clients.